Your contest registration deadline is in 3 days. We'll need your organization's event permit on file by Friday, or we'll have to pull your access to the lake." She said it the way someone says a thing they have said 100 times before. Flat, certain, with the particular confidence of a person who has never been told no. Her name was Renata Voss, and she was the events coordinator for the Ridgeline Pines Homeowners Association. Standing in my driveway on a Tuesday morning in late November with a clipboard under one arm and a laminated badge on a lanyard, and she had no idea. No idea that the 2 lakes she was scheduling fishing contests on, the access road her members drove to reach them, the 2,900 acres of alpine meadow and timber and granite ridgeline surrounding every inch of it, all of it was mine. I had inherited it 11 months earlier. I had the deed in a drawer in my kitchen, inside a manila folder my attorney had handed me across a conference table, and I had been reading it slowly ever since, learning what I owned. Drop a comment and tell me where you're from, and if something like this has ever happened to you, I want to hear it. I told Renata Voss I would look into the permit question. She thanked me in the crisp tone of someone who does not expect to be questioned and drove back down the gravel road in a white SUV that had never, I was fairly certain, been off pavement before that morning. The thin November air smelled of pine resin and the faint iron cold that comes before the first hard freeze, and I stood there for a long moment watching the dust her tires had raised settle back onto the road. My road. I was not angry. I want to be clear about that. I was, if anything, curious. The question she had raised, who had authority over those lakes, was one I had been turning over quietly for the better part of a year, and she had just handed me a reason to stop turning it over and start answering it. Let me take you back to where this started. My grandfather's name was Everett Calhoun, and he came to the high country of central Colorado in 1951 with a geologist's eye and a carpenter's hands and the particular stubbornness of a man who had decided the land was worth more than anyone around him believed. He had worked the mines near Leadville for 3 years, saved what he could, and in the spring of 1954 purchased the first parcel, 480 acres on the western slope of what the county plat maps called the Ridgeline Pines Basin. The price was $4.30 per acre, paid in full, recorded in Chaffee County on April 9, 1954. I know the exact date because I have the original deed, handwritten in a clerk's careful cursive, folded inside a plastic sleeve inside the same manila folder that holds every subsequent instrument touching that land. Everett did not stop at 480 acres. He added parcels in 1957, 1963, and 1971. He traded timber rights on the eastern ridge for clear title to the lakebed parcels, a transaction his attorney called unusual but entirely legal, recorded in full. By the time my grandfather died in 1988, the property had grown to just over 2,400 acres, encompassing both alpine lakes. The upper one the county maps called Calhoun Lake, and the lower one the family had always called the Second Lake, though its recorded name was Ridgeline Tarn. My grandmother held the property through a family trust after Everett died, and my father, their only son, Robert Calhoun, managed it from a distance, driving up from Denver 4 or 5 times a year to check the fences, clear the access roads, and pay the property taxes without fail for 31 years. The final 500 acres were added in 2003 when a neighboring parcel came available after its owner died without heirs. My father purchased it through the trust, And with that acquisition, the property reached its current total: 2,900 acres, 2 lakes, 1 gravel access road running 7 miles from the county highway to the upper lake, and a small winterized cabin near the lower lake's eastern shore that my grandfather had built with his own hands in 1961. The cabin still stands. The cedar shingles are original. The iron stove inside it came from a hardware store in Salida that closed in 1979. My father died in the second week of January of last year. The end, when it came, was not a surprise, but the weight of what he left behind was something I was not entirely prepared for. I am a civil engineer by training and by habit. 22 years designing drainage systems and retention structures for municipalities along the Front Range. And I am accustomed to reading documents carefully, to understanding what a piece of paper actually says as opposed to what it appears to say at first glance. But the scope of what I inherited took me several months to fully absorb, not the acreage itself. I had known about the land my whole life, had walked its ridgelines as a boy, had sat with my grandfather on the dock at Calhoun Lake, watching the mallards work the shallows in the early morning. What I had not fully understood was the administrative history of the land, the various agreements and easements and use arrangements that had accumulated around it over 70 years. A large piece of property, left mostly unmanaged, tends to acquire a kind of informal gravity that pulls other people's assumptions into orbit around it. The attorney who handled my father's estate was a woman named Patricia Olson, a property specialist in Colorado Springs who had handled the trust documents for 15 years. She was the one who handed me the manila folder. She was also the one who, during our second meeting, mentioned almost in passing that she had noticed a discrepancy in the county's parcel record she thought I should be aware of. The discrepancy was this: Ridgeline Pines HOA, incorporated in 1997 to govern a residential development of 47 homes on the northern slope of the basin, had been operating as though it held recreational access rights to both Alpine lakes. Not just informal access, organized, scheduled, advertised access, annual summer fishing derbies, a kayak registration program. And, as I would learn in November, when Renata Voss appeared in my driveway, a winter ice fishing contest that had been running for at least 6 consecutive years. Patricia had flagged the discrepancy because she had searched the county's recorded instruments and found no easement, no license agreement, no deed of access, and no recorded covenant granting Ridgeline Pines HOA any legal right to use either lake. What she found instead was a 1999 letter from my father to the HOA's founding board president, a man named Gerald Forsyth, in which my father had given informal written permission for HOA members to fish the lower lake during summer months, subject to conditions, and explicitly noted that this permission was personal, revocable, and did not constitute an easement or any permanent right of access. The letter was not recorded. It was not a deed. It was a neighborly gesture from a man who spent most of his time in Denver and liked the idea of the property being used rather than sitting idle. Gerald Forsyth had died in 2008. Whatever understanding he had carried about the nature of that permission had died with him. What the HOA's subsequent boards had done over the 15 years that followed was something I recognized immediately. They had treated informal permission as permanent right, expanded it gradually from the lower lake to both lakes, from summer fishing to year-round recreational programming, and had never once sought to confirm the legal basis of what they were doing. They had, in the particular way that institutions sometimes do, mistaken the absence of objection for the presence of authorization. I read my father's 1999 letter 4 times. The language was unambiguous. This permission is personal to the current board and its members, is revocable at any time at my sole discretion, and does not create any easement, covenant, or permanent right of access to either lake or to any portion of the Calhoun family property. My father had been a careful man. He had written it that way on purpose. I put the letter back in the folder and looked out Patricia's office window for a moment. Then I asked her how long the ice fishing contest had been running. 6 years, she said, possibly 7. I asked whether the HOA had ever applied for a permit, filed a notice, or sought any formal acknowledgement of their use from the trust or from my father's estate. She said no, not once. I thanked her, picked up the folder, and drove home. The mountains were visible from the highway for most of the drive north, the high ridge lines carrying their first snow of the season, pale and clean against a sky the color of old pewter. I thought about my grandfather on that dock in 1961, watching the water. I thought about my father driving up from Denver to check the fences. I thought about the 47 houses on the northern slope and about Renata Voss and her clipboard, and about the ice fishing contest scheduled to begin in approximately 6 weeks. I was not angry, but I was paying attention now in a way I had not been before. The certified letter from Ridgeline Pines HOA arrived on a Wednesday morning, forwarded from my father's estate address to my home in Colorado Springs. It was printed on HOA letterhead, a small pine tree logo in the upper left corner, the association's name in a font that wanted to suggest permanence and authority. The letter was signed by Renata Voss in her capacity as Events and Compliance Coordinator, addressed to the Calhoun Family Trust. Attention, current trustee. The salutation read, "Dear Trustee," as though my name were an inconvenience they had not yet gotten around to learning. The substance was a formal notice of the upcoming Ridgeline Pines Winter Ice Fishing Classic, scheduled for the second Saturday of January, to be held on Ridgeline Tarn. The letter stated that the event would accommodate up to 60 registered participants, that the HOA's event committee would be placing numbered ice fishing stations across the lake's surface beginning the Thursday prior, and that the association's grooming equipment would require access via the main gravel road starting at 6 in the morning on the setup day. There was a paragraph about liability in which the HOA noted that it carried its own event insurance and that the association assumed no responsibility for conditions of the lake surface or surrounding terrain. I read that paragraph twice. The association was informing me, on my own land, that it assumed no responsibility for conditions on my lake. The letter closed with a line I found genuinely remarkable. We appreciate the long-standing cooperative relationship between the Calhoun Trust and Ridgeline Pines HOA, and we look forward to another successful season of community recreation. Long-standing cooperative relationship. There it was. 15 years of unchallenged assumption compressed into 4 words. I set the letter on my kitchen table next to my father's 1999 permission letter, next to the deed, next to Patricia's preliminary title search summary. I looked at them together for a while. Then I called Patricia. She answered on the second ring, and I read her the closing line of the HOA's letter. There was a pause, and then she said, in the dry, even tone of a woman who has been practicing property law for 30 years. "Well, that's interesting." I told her I thought so too. She asked me what I wanted to do. I told her I wanted to do it correctly and I wanted to do it thoroughly, and I was in no particular hurry. She said she would begin a full title search on both lake parcels and the access road the following morning, and would also pull the HOA's recorded covenants and declaration of restrictions from the county recorder's office, because she wanted to understand exactly what authority the association's governing documents actually granted it, and over what land. The search would take approximately 2 weeks. I said that was fine. The ice fishing contest was 6 weeks away. 2 weeks was fine. The title search documents arrived in a single large envelope on a Thursday afternoon, organized in the way a careful attorney organizes things when she wants you to understand not just the conclusion but the reasoning. 43 pages in total. The first section covered the chain of title for both lake parcels, tracing ownership from the original federal land patent through every subsequent conveyance to the present. A clean, unbroken line, ending with my name as successor trustee of the Calhoun Family Trust. The second section covered the HOA's recorded governing documents, its declaration of covenants, conditions, and restrictions, filed with Chaffee County in August of 1997, along with its articles of incorporation and its plat map showing the 47 lots in the Ridgeline Pines subdivision. I studied the plat map for a long time. The subdivision occupied approximately 340 acres on the northern slope of the basin. Its boundary lines stopped clearly and unambiguously at the edge of the Calhoun Trust parcels. The 2 lakes were not inside the subdivision boundary. The access road was not inside the subdivision boundary. Not 1 inch of the 2,900 acres was within the jurisdiction of the HOA's recorded covenants. The HOA's declaration was explicit. Section 2.1 defined the association's authority as extending to all lots and common areas within the Ridgeline Pines subdivision as depicted on the recorded plat. Section 4.3 defined common areas as those parcels designated as common area on the recorded plat. The lakes were not on it. The access road was not on it. The word Calhoun did not appear anywhere in the HOA's governing documents. The association had been operating recreational events on land its own governing documents gave it no authority to touch. Patricia had attached a handwritten note to the front of the envelope. The 1999 letter is the only instrument. It is not an easement. It is not a license. It is a personal permission from a private individual, revocable at will. Call me when you have read through this. I called her that evening. She confirmed what I had already concluded. The HOA had no legal basis for any recreational use of either lake, the access road, or any other portion of the Calhoun Trust property. The 1999 letter could be revoked by written notice at any time. If the HOA proceeded with the ice fishing contest without a formal license agreement, it would be conducting a commercial recreational event on private land without authorization. She asked me again what I wanted to do. I told her I wanted to send a letter. The letter Patricia drafted ran 4 pages, organized as a record, something that would be read again later in a different room by people who were not present at the drafting. It identified the sender, the subject, and the instruments. The original 1954 deed, the subsequent acquisition instruments of 1957, 1963, 1971, and 2003, each cited by recording book and page number, each assessor's parcel number included. The critical paragraph stated in plain language that the trust had conducted a review of all recorded instruments affecting the subject parcels, had found no recorded easement, license agreement, deed of access, or covenant granting the HOA any right to use or conduct events upon the Calhoun Trust property, and that the Trust was aware of the HOA's practice of conducting organized recreational events on the Trust's lake beds without formal authorization. The letter then made a request, not a demand, a request. It asked the HOA's board to provide, within 30 days, any recorded instrument it believed established a legal right of access so that the Trust could review it. The final paragraph noted that the Trust was not, at this time, requesting cancellation of the upcoming ice fishing contest, but reserved all rights with respect to the use of its property. Patricia had wanted to include a revocation of the 1999 permission in this first letter. I had asked her not to. I wanted to see what the HOA produced before I played that card. I wanted to know whether anyone on the current board even knew the 1999 letter existed. She sent it by certified mail, return receipt requested. The receipt came back 11 days later. Someone had signed for it. The signature was not Renata Voss's. I had a neighbor at the property, not adjacent in the conventional sense, but a man named Dale Hutchins, who ran a small grazing operation on a parcel sharing a fence line with the Calhoun Trust's eastern boundary for about a mile and a half. Dale was in his late 60s, had lived in the basin his whole life, and had known my grandfather. He had the particular quality of a man who has watched a great deal happen from a distance without involving himself, and who therefore remembers things with a precision that more involved people rarely achieve. What Dale knew was considerable. He remembered the HOA's founding in 1997, remembered Gerald Forsythe going door to door in the new development to sign people up. He remembered a conversation at the Salida hardware store around 1999 or 2000 in which Forsythe had mentioned working something out with Robert Calhoun about the lakes. Dale had understood at the time that it was an informal arrangement. He said the word Gerald had used was permission, not rights, and he remembered that word because he had thought it was exactly the right word and nothing more. Dale also told me something I had not known. Around 2010 or 2011, 2 or 3 years after Gerald Forsythe died, the HOA had put up a small wooden sign at the turnoff from the county highway onto the gravel access road. The sign read, "Ridgeline Pines Recreation Area, Members Welcome." Dale had noticed it because the turnoff was visible from his east pasture and because he had thought at the time that it was an unusual thing to put on a road that did not belong to the HOA. I drove out to the property the following weekend. The sign was still there, weathered now, the paint faded to pale gray but legible, mounted on 2 4x4 posts at the edge of the access road approximately 40 feet from the county highway right-of-way line. I photographed it from several angles, noting the GPS coordinates on my phone. Then I drove the 7 miles to the upper lake and back, photographing the road surface and the gate at the 2-mile mark, a gate with a combination lock on it that I had not installed and did not know the combination to. I photographed the lock, I photographed the gate, I photographed the latch hardware and the posts, which were set in concrete that looked to be at least several years old. Someone had installed a gate on my access road, with a lock that I did not have the combination to. I was not angry, but I was building a file with a thoroughness I had previously reserved for drainage infrastructure reports. The HOA's response to Patricia's letter arrived on a Friday afternoon, 3 weeks after the certified mail receipt had come back. 2 pages, printed on the same pine tree letterhead, signed by a man named Curtis Bale, who identified himself as president of the Ridgeline Pines HOA Board of Directors. I read it standing at my kitchen counter, then sat down and read it again. Curtis Bale's letter did not produce any recorded instrument establishing a right of access. What it produced instead was a theory. The HOA had been using the lakes for recreational purposes for more than 20 years, with the knowledge and consent of the prior property owner, and this long-standing use had, in the HOA's view, ripened into a prescriptive easement under Colorado law. The letter cited Colorado Revised Statutes, Section 3841-101, which governs adverse possession, and made a passing reference to prescriptive easement doctrine without citing the specific elements required to establish one. It also mentioned the sign at the highway turnoff, describing it as evidence of the HOA's open and notorious use of the access road. Language drawn directly from adverse possession doctrine. Someone on the board, or someone advising the board, had been doing some reading. I set the letter down on the kitchen table next to Patricia's title search, next to the deed, next to the photographs of the sign and the gate and the lock. Then I picked up the phone. Patricia answered on the third ring. I read her the prescriptive easement theory. There was a pause, and then she said, in the same dry tone she had used before, "Well, that changes the letter we send next." I asked her to walk me through the elements required to establish a prescriptive easement in Colorado. She said that Colorado courts required the claimant to demonstrate open, notorious, continuous, and adverse use of the property for a period of 18 years, and that the use had to be without the owner's permission. That last element was the critical one. If the use had been permissive, if the owner had given permission, even informally, the prescriptive easement clock never started running, because permissive use was by definition not adverse use. I told her about the 1999 letter. She already knew about it, of course, but I told her I wanted it to be the centerpiece of whatever we filed next. She agreed. The 1999 letter, in which my father had explicitly granted personal, revocable permission for the HOA's use of the lower lake, was a complete bar to any prescriptive easement claim, because it established that the use had been permissive from its inception. Permissive use, once established, remained permissive unless the claimant took some affirmative action to put the owner on notice that the use had become adverse, a notice the HOA had never given. The sign at the highway turnoff was interesting, but a sign erected by the claimant on the claimant's own theory of right, without the owner's knowledge or acquiescence, did not transform permissive use into adverse use. She would prepare a formal legal response, attach a certified copy of the 1999 permission letter, and in the same response formally revoke that permission. The revocation would be effective upon receipt. I asked her to include a specific notice that the gate on the access road was to be removed within 30 days, as it constituted an unauthorized installation on private property. She said she would include it. I thanked her and set the phone down. Outside the window, the mountains were carrying a heavy snow now, the ridge lines white from base to summit. The sky above them a flat, pale gray that pressed down on everything with the weight of a Colorado winter fully committed to itself. Somewhere up there, under that snow, Calhoun Lake was frozen solid, and I thought about my grandfather testing ice with a hand auger before he trusted it, walking out from the dock in careful steps, reading the surface the way he read everything, slowly, with his full attention, not assuming it would hold until he knew that it would. The HOA had been walking out onto ice for 20 years without ever testing it. They had assumed it would hold because it always had. They had not thought to ask why. The response Patricia sent was 8 pages. It arrived at the HOA's registered address by certified mail on a Wednesday morning in early December, and the return receipt came back 4 days later with Curtis Bale's signature on it. The letter laid out the prescriptive easement elements under Colorado law with the precision of a brief, citing case law, citing the statutory period, citing the permission element and its legal effect on the adverse use requirement. It attached a certified copy of the 1999 letter. It formally revoked the permission granted therein, effective upon receipt. It notified the HOA that any further use of the Calhoun Trust property without a formal written license agreement would constitute trespass, and it demanded removal of the gate and lock within 30 days, identifying the gate's location by GPS coordinates, and noting that its installation had been unauthorized. The final paragraph stated that the trust was prepared to discuss the terms of a formal license agreement if the HOA wished to pursue one, but that no such agreement would be entered into under any claim of existing right. I had Patricia send a copy to the Chaffee County Assessor's Office and to the County Attorney's Office for their records. The ice fishing contest was 3 weeks away. The gate was still on my road, and Curtis Bale had not yet responded. That was all right. The letter had been received. The clock was running, and in my experience, in 22 years of designing systems that moved water through terrain that did not always cooperate, the most important thing about a well-built structure is not the moment you finish it, but the quiet certainty that it will hold when the pressure comes. I had built the structure. Now I waited for the pressure. The hearing was held on the second Thursday of January, 8 days before the ice fishing contest was scheduled to begin, in a conference room at the Chaffee County Administrative Building in Salida. A low, practical room with fluorescent lighting and a long table and chairs that had been purchased sometime in the 1990s and showed it. Patricia had requested the hearing through the county attorney's office after Curtis Bale's second letter arrived, escalating from a prescriptive easement theory to a formal threat of legal action against the trust for what Bale called interference with established community recreational rights. He had retained an attorney named Philip Garrett, who practiced out of a firm in Pueblo and whose letterhead announced, in small capitals beneath his name, a specialty in community association law. Garrett's letter had been longer and more carefully worded than Bale's, but made the same essential argument. 20-plus years of continuous, open, and notorious use, with the knowledge of the prior owner, had ripened into a prescriptive easement the trust was now obligated to recognize. Patricia had read Garrett's letter and told me, in the tone she reserved for things she found professionally interesting rather than professionally alarming, that she was glad the HOA had put its theory in writing. Garrett had built his entire argument on the premise that the use had been continuous and adverse. He had not mentioned the 1999 letter. He had not mentioned it because he did not know it existed. The HOA had not told him, which meant that either no one on the current board knew about it, or someone did and had decided not to share it with their own attorney. Either way, the letter existed. It was in the file, and it was about to enter a room. The county attorney's office had convened the hearing as a pre-litigation review, a preliminary matter to determine whether there was a legitimate dispute of recorded title warranting formal court proceedings, or whether one party's claim could be resolved on the face of the recorded instruments alone. It was not a trial. There was no jury. There was a county hearing officer named Margaret Solano, who sat at the head of the table with a legal pad and a pair of reading glasses, and the quiet authority of a woman who had been sorting out land disputes in this county for a long time. Curtis Bale was there, in a blazer slightly too formal for the room, with Philip Garrett beside him and two board members I did not recognize seated along the wall. Renata Voss was there as well, with her clipboard and her laminated badge, though she sat at the far end of the table and did not speak. I was there with Patricia, who had brought the full file in a banker's box that she set on the table without ceremony and did not open until she needed to. Garrett spoke first, identifying the HOA and its claim of prescriptive easement over the Calhoun Trust property, specifically the two Alpine lakes and the access road. He was precise and confident, laying out the elements in order: open, notorious, continuous, adverse, 18 years, with the assurance of a man who had made this argument before and expected it to land the way it always had. Patricia identified herself and the trust and said she was prepared to address the claim on the record. Margaret Solano said she had reviewed the recorded instruments submitted by both parties and had some questions. She looked at Garrett and asked him to confirm the date on which the HOA's use of the Calhoun Trust property had begun, as claimed in the HOA's submission. Garrett said the use had begun in approximately 1999, when the HOA's founding board president had established a recreational access arrangement with the prior property owner. Margaret Solano wrote something on her legal pad. Then she looked at Patricia. Patricia opened the banker's box and removed a single document in a clear plastic sleeve. She set it on the table and slid it to Margaret Solano without speaking. Margaret Solano picked it up and read it. She read it slowly, checking each element. The room was quiet enough that the fluorescent lights were audible, a faint, steady hum pressing down on everything. The document was the 1999 letter. My father's letter. The one that used the word permission. The one that said, in the careful language of a man who had thought about what he was writing, that the permission was personal, revocable, and did not create any easement, covenant, or permanent right of access. Margaret Solano set the letter down and looked at Garrett. She asked him whether he was aware of this instrument. Garrett looked at the letter. He picked it up and read it. He read it a second time. Curtis Bale leaned over and read it with him, and I watched something shift in Bale's face. A small, involuntary rearrangement of the muscles around his jaw. The expression of a man who has just understood that a load-bearing assumption has been removed from beneath him. Garrett set the letter down and said, carefully, that he had not previously been provided with this document. Margaret Solano said she understood. She said that the document appeared to be a written permission from the prior property owner to the HOA's founding board dated 1999, which was the same year the HOA's claimed use had begun, and that the document explicitly characterized the permission as personal, revocable, and non-easement creating. She asked whether, in light of this instrument, the prescriptive easement claim could be maintained. Garrett asked for a brief recess to confer with his client. Margaret Solano granted 10 minutes. I sat with Patricia at the table while Bale and Garrett and the two board members moved to the corridor. Renata Voss stayed in her chair at the far end, looking at the 1999 letter that Margaret Solano had set back on the table's surface. She was looking at it the way you look at a thing you recognize but cannot place. I did not know whether she had known about the letter. I did not ask. Patricia poured herself a glass of water from the pitcher on the table. She did not say anything. Neither did I. When Garrett came back, he said in the measured tone of an attorney managing a position that has just become significantly more difficult, that the HOA wished to withdraw its prescriptive easement claim pending further review of the documented record. He said the HOA did not concede that the 1999 letter was necessarily dispositive of all questions, but that it wished to evaluate its position in light of the instrument before proceeding further. Margaret Solano said she appreciated that, and then she said something I had not expected and thought about for a long time afterward. She said that, in her review of the recorded instruments, she had also noted the gate and combination lock installed on the access road, and that this installation appeared to have been made on private property without the owner's authorization, and that she was noting this in the record as a matter of concern the trust might wish to pursue separately. Garrett said the HOA would address the gate. Margaret Solano said she expected so. She closed the proceeding by noting that the HOA's prescriptive easement claim had been withdrawn, that the trust's title to the subject parcels was uncontested on the current record, and that any future use of the Calhoun Trust property by the HOA or its members would require a formal written license agreement executed by the trust. She said she would issue a written summary of the proceeding to be filed with the county recorder's office as a matter of public record. The ice fishing contest did not happen that January. The HOA sent a notice to its members 2 days after the hearing, canceling the Ridgeline Pines Winter Ice Fishing Classic due to, as the notice put it, unresolved access questions. I did not see the notice directly. Dale Hutchins sent me a photograph of it, taken from the HOA's community bulletin board. He had driven to the development's entrance to check his mail and had seen it posted there, and he had photographed it with his phone and sent it to me without comment. It is, technically speaking, one of my favorite pieces of documentation in the entire matter. The gate came down 3 weeks later. I drove out to the property on a Saturday morning in early February, and it was gone. Posts, concrete footings, lock and all, removed so thoroughly that the only evidence it had ever been there was 2 circular patches of disturbed gravel where the footings had been pulled. I parked the truck and stood there in the cold, looking at the road running clean and open up through the timber toward the upper lake, the way it had always run, the way my grandfather had driven it in a truck that was old when he bought it, hauling cedar posts and hand tools in the particular conviction that the land was worth the work. I drove the 7 miles to the upper lake and sat for a while on the dock my grandfather had built, which still holds, which is still level, which still smells of the particular combination of pine and cold water and old cedar that I have known since I was a boy. Calhoun Lake was frozen solid, the surface a pale, opaque white in the February light, and the mallards were gone to warmer water for the winter. But the lake was there. The ridge line above it was there. The 2,900 acres of alpine meadow and timber and granite were there, holding their quiet under the snow the way they had held it for 70 years, the way they would hold it after I was gone. The county recorder's office filed Margaret Solano's summary in the 3rd week of February. It noted the withdrawal of the HOA's prescriptive easement claim and confirmed the trust's uncontested title to both lake parcels and the access road. The HOA's board voted at its February meeting not to pursue further legal action. Curtis Bale did not seek re-election to the board that spring. Renata Voss's events coordinator position was eliminated in a budget restructuring the following summer. I learned these things from Dale Hutchins, who continued to notice things from a distance with the precision of a man who has spent a lifetime watching without involving himself. Patricia sent me the final billing statement with a note that said the matter had resolved as cleanly as any she had handled in recent memory, and that the 1999 letter had done more work than most instruments twice its length. I filed the statement in the banker's box, next to the deed, next to the title search, next to the certified mail receipts and the hearing summary and the photograph of the canceled contest notice from the HOA's bulletin board. The lesson, if there is one, is not complicated. When an institution with apparent authority makes a claim against you, the first question is not whether the claim feels legitimate. It is not whether the institution has a badge, or a blazer, or a laminated lanyard, or 20 years of unchallenged assumption behind it. The first question is whether the claim has a legal foundation. And the answer to that question is always in the record, in the deed, in the plat map, in the county recorder's office, in the instruments that were filed and signed and dated and preserved against exactly this kind of moment. The record does not care about confidence. It does not care about tradition or community or the particular certainty of a person who has never been told no. It cares only about what was written down and when and by whom and what it actually says. My grandfather understood this. He wrote things down. He recorded them. He kept the instruments in order because he had learned, somewhere in his years of work in the high country, that the land itself does not argue on your behalf. The paper does. The paper, kept carefully in a drawer in a folder, is the argument. It is the only argument that holds. I drove back down the 7 miles of gravel road that February morning, through the timber and the meadow and the granite, past the place where the gate had been, and out to the county highway, and I turned south toward home. The mountains were behind me in the rearview mirror, white and enormous, and entirely indifferent, the way they had been in 1954 when my grandfather drove the other direction on this same road with the deed folded in his coat pocket, and the way they would be long after the last of us was done arguing about who owned what. The road was mine. The lakes were mine. The record said so. That was enough. If any of this sounds familiar, a boundary dispute, an HOA overreach, a piece of land someone else decided they had a right to, leave a comment. These cases are more common than most people realize, and I find that the details matter. And if you want to be here for the next one, subscribing is the simplest way to make sure you don't miss it.